Good morning, everyone, and thanks so much for joining us in what we hope will be a series of informative compliance business immigration webinars in the future. Before I introduce today's esteemed speakers, some housekeeping. So everyone is muted by default and your cameras are off. So you'll only be able to see the presenters speaking as opposed to the other attendees. You can click on the top bar with the two arrows to maximize your screen, should you wish to. There's also a chat function, and at the bottom we have ensured that the chat is private, so feel free to ask any questions. We'll have a Q&A to answer some of the questions at the end. If you have kind of direct, specific or sensitive questions, our contact details will be shared with you, and you're welcome to reach out directly for a free, no obligation conversation. To give you a brief overview of Sable International and who we are specialists in immigration and international financial services and have been providing a boutique range of services for over 30 years. We have offices around the world and are generally able to provide a bespoke, customer-centric service suited to a range of clients. To introduce today's speakers, the first speaker that we have is Darren Fife. Darren has over 25 years experience heading award-winning organizations and providing immigration and compliance services to large-scale multinational businesses. Having run his own successful immigration practice for over 20 years, Darren possesses a strong commercial mindset and provides an efficient delivery of strategic solutions. Darren has a wealth of knowledge and experience, and I have no doubt he'll be able to provide us all with some great insight into the compliance of UK immigration. Julian Dearson started his immigration journey with the Home Office nearly 40 years ago. He went on to found Dearson Vineyard over 30 years ago. He has decades of experience in corporate immigration and immigration compliance. He now heads up our immigration compliance service within business immigration, which offers a comprehensive immigration compliance audit service for UK businesses. Julian is a household name in the UK immigration world, and we're delighted that he has recently joined the Sable family. In terms of the agenda of today's presentation, we'll be going through sponsor responsibilities and compliance, prevention of illegal employment, maintaining migrant contact details, record keeping, migrant tracking and monitoring, and some general requirements. We'll close off with a Q&A, so if you do have questions, feel free to post them. And without further ado, I will hand over to Darren and Julian.
Thanks, Saskia. Hi, everybody, and thanks for joining us today. I'm going to run through the illegal employment aspects of sponsor responsibilities, and then Julian's going to take you through the other four sections which relate to when the Home Office come to your premises and conduct a compliance visit. Julian will be running through those kind of areas they'll be looking at and how they'll be looking at them and the kind of things you need to be aware of. Prevention of illegal employment is essentially right to work and how companies manage that. We have something that's called the statutory excuse, which is fundamentally what we're going to be talking about establishing today. The companies who do not have this can stand to be fined a civil penalty of up to £20,000 per worker. Additionally, if you have a sponsor license, which I assume most of you will, that can be removed from you if you fall foul of this legislation. And the issue with that, not only does it restrict your ability to then hire any migrants into the business, it will also remove those migrants that are already in the business. So when they take your license away, anybody who's already in the business would need to leave. So it has a lot of risk attached to it. To establish the statutory excuse, we need to be obtaining and verifying certain documents, and these documents might differ depending on the type of employee we're talking about. So for our UK nationals and Irish nationals and UK residents, we have what's called List A. And List A establishes a continuous excuse for the duration of the individual's employment. And when I say excuse, what the Home Office say is if you are found to be illegally somebody is found to be illegally working in your business, either knowingly or unknowingly, if you don't have this process in place, they will fine you. However, if you do have a process in place, you have followed the prescribed method of checking and documenting right to work, then you have what's called the statutory excuse. That's your statutory defence against that fine and any sanctions that are made against you. So essentially, if you followed the process and somebody's then found to be working illegally, you won't be fined. So with our British nationals or Irish nationals, we'd be looking to see a passport or some other document from an overseas national to show they have indefinite stay in the UK with no time limit or restriction on their ability to work. For those on List B, we have what's called a time-limited excuse. These are individuals who have a time restriction on their stay. It may include somebody like a skilled worker, somebody on a spousal visa, certain categories of student, somebody on UK ancestry. Anybody that has a time limit on their stay would be considered to be List B. And with these guys, we need to check and document their right to work, just like we do with the British nationals, but we also have a requirement to continually check them every time their visa is due to expire. Now, this was changed in 2014. The legislation originally came in 2018, and it required you to conduct a check every 12 months, regardless of when the visa expired. From 2014, the Home Office changed that to say you only need to check it when the visa is due for expiry. So it does mean that you need to have a system in place to diarise people's visa expiry. So it's not just good enough to copy it once when they start work. We have a requirement to continuously check these individuals. Now, the methods of checking, there's basically four ways. The traditional way is the manual check. This is what most of you will probably be doing, where we have the original document and we have the person standing in front of us, and we need to check that the individual is the rightful holder of that document, when we need to satisfy ourselves that the document is a genuine one to the best of our ability. So any forgery or counterfeit documents would need to be reasonably apparent. So the Home Office don't expect you to be a forgery expert, but they do expect you to identify an obvious forgery or something that doesn't look right. So that's the manual check, and that's the traditional way of doing things. As of April last year, we had the new system where you can use an identity service provider. Now, the IDSPs, as they're known, they use something called digital verification technology. So they will input the individual's details into their system, and that will spit out the other end a verified identity. Now, the Home Office have only approved 39 companies to do this. Now, quite often those companies will also be doing DBS checks and other background screening procedures for your business. And you can use these guys to conduct your right to work check. But you will still need to satisfy yourself that the person who you've employed is that person in those documents. So there are two elements to using one of these IDSPs. You are able to use IDSPs that are not on the list, but then you need to be satisfied that they are following the Home Office procedure, and there's a whole document around that. So I'd suggest if you are going to use one of these guys to conduct your checks for you, I'd probably pick one from that list of 39. Now, EU nationals and other non-British and Irish nationals are now all on biometric residence permits, and they have an online status. So the third method is via a share code, and the individual will log into their profile, generate a share code, provide you that code, and then you'll log into the Home Office portal, and you'll be able to download a PDF which also has a photograph of the individual and their conditions of stay. Again, you need to satisfy yourself the individual standing in front of you is the individual in the document, and that would satisfy your statutory excuse. And the last method is the employer checking service. This is for candidates who are unable to provide their documents because they have an outstanding application with the Home Office. We have to bear in mind that sometimes an individual may be able to work in the UK, but they've submitted an application, and it could be a number of months for the Home Office to actually consider and complete that case. In those circumstances, you'd use the employer checking service, and the Home Office would provide you with a response confirming positively or negatively whether the individual can work for that period. So that really they've given candidates no excuse not to provide some kind of evidence. And certainly as an employer, unless you've got one of those four things on file, you would not satisfy the requirements of that statutory excuse. The other thing to point out here is there were COVID measures in place due to remote working and people not being able to go into the office from March 2020 until last September. You could conduct a lot of these checks online via a video link. You can still do that to a degree, but you need to have the original passport in your hand and satisfy yourself via video link the individual is that person. Under the COVID measures, you could accept a copy and the individual would hold up that original document next to their face on the video call. That's no longer the case. You don't need to change it retrospectively. So if you've hired somebody pre-30th September, that check is still valid. But after September, so 1st of October onwards, you need to have had the original document in your hand so you can satisfy yourself it's a true and genuine document. And I will hand over to Julian.
Thank you, Darren. Good morning, everybody. Thank you for your time this morning. So, yeah, I'm going to cover the other four main areas that a compliance officer will be interested in during a compliance audit. The first area is maintaining contact details for sponsored migrants. This includes address, mobile phone. Other contact details also include personal email addresses. The Home Office expect that this information is kept up to date. So we would always recommend, at the very least, an annual email to. I would advocate all workers, but certainly it has to be going to sponsored workers to check that the details are correct. And you also have to keep a historic record of previous addresses. Now, I know a lot of you will these days will use HR systems that are online. Some of those systems don't keep these historic addresses, so you need to be aware of that, and possibly if your system doesn't do that, then you possibly need to print off and retain those historic details. The other thing is that the reason that the Home Office will want you to maintain this information is because if you stop sponsoring a migrant, you will need to provide up-to-date contact details for them to approach the individual, because it may well be that they have their leave curtailed or whatever. And if you're unable to do that, then the Home Office will hold you responsible for that situation. So it's very important. It's quite a simple thing to do, but it's a very important that you get those and maintain those details. So moving on, record keeping. Now, this is a very, very broad area. Basically, it's about maintaining a industry acceptable HR file. It doesn't have to be a manual, it can be an electronic file. And these days, as I mentioned earlier, more and more companies are moving towards electronic management of HR files. In terms of what needs to be kept for sponsored migrants, if a recruitment process has been undertaken as part of the application, that needs to be retained in its entirety. So that includes the advert itself, responses, interviews, and shortlists, etc. So that all needs to be retained, and it all needs to be accessible at the time of an audit. Also, the Home Office would expect to see references and qualifications. They don't insist on verification, but they do expect you to be able to explain how you verified them. So it's a bit, we would, and Darren mentioned the IDSPs who do background screening. We would, if the whole issue around sponsoring migrants is that the Home Office make it very clear that it is not a right, it is a privilege, and you have to kind of buy in to what they expect you to do. And undertaking background checks is one of those. They like to see it's a tick in the box that shows that you are engaged with what you're supposed to be doing as a sponsor. The records can be, as I say, they can be retained either electronically or manually. In terms of things like keeping records of contract of employment, bizarrely, there isn't a necessity to have a contract of employment, but you have to have a document that shows working hours, salary and deductions. So these days, contracts of employment, it's unusual that there isn't one. But again, that should be kept. And that should also include the start date of the employment. There is an extensive list about record keeping, and this kind of gives you a flavour of what it is. During an audit, the Home Office will accept that. Okay, it depends what causes the audit. So if it's an arranged audit, then the Home Office will expect to have access to pretty much everything. If it's an unannounced audit, then they accept that information may not all be available because there may be passwords that protect some of that information from access to everybody. But it is something that you need to be aware of, that they will ask to see that. So moving on to migrant tracking and monitoring, again, this is part of the responsibility that you have as an employer who is sponsoring migrant workers. And there's a whole raft of circumstances that you will have to report changes in circumstances to an employment situation. Again, the list here is pretty extensive. If the sponsor worker doesn't start the role on time, if they're absent for more than 10 working days without permission. So again, that on the face of it, it's like, okay, fine, but you then need to establish the process that you have in place to monitor those absences. So again, that comes back to, you know, in a lot of cases, the HR system that you use, and to make sure that somebody is monitoring those absences and is taking responsibility for those. Obviously, if the sponsored worker resigns or is dismissed, you have to report that. If they stop working for any other reason, if they move their category from a sponsored worker, maybe they get married to a UK resident or British citizen, and they change their status, you still have an obligation to report that as part of your sponsor duties. If they are for 4 weeks, absence is so they start to do less hours, or they're without pay, then you need to report that to the Home Office. If they are working on a client site in one location and that client site, and they move to a different client site, that needs to be reported. So there's a whole raft of responsibilities that you have as an employer in terms of reporting to the Home Office the activities of your migrant workers. And following on from that, the last bit is your general sponsor duties. So again, if there's a change in your business, if there is a change in the location of the business, if you are taking over, if you take over another business, if you relocate, all of these things are require notification to the Home Office. Some of those are time restricted, and again, I'm assuming the vast majority of you are clients of Sable, and this goes back to the previous point as well. Any changes that you're not sure about, please check, because it may seem to you that it's kind of like it's a small minor change, but it may prompt the requirement to notify the Home Office of that change. So that's pretty much it in terms of the presentation.
I think the other thing to mention on the general sponsor duties, the Home Office do periodically check Companies House, and if they spot a change in ownership or shareholding and all that kind of stuff, and we haven't told them about that change, it will quite often trigger a compliance visit. Because
and that will probably be an unannounced one, because they would consider that there is a potential breach.
Okay.
Oh, thank you very much, Julian and Darren. So there's quite a few questions that have come through, so we'll go through those Q&As. If anyone else has questions, feel free to post them in the chat and we'll try to get to as many as we can. One for Darren. Can you do a right to work check online or over video?
The answer is yes and no. Under the COVID measures, absolutely. You could receive a scanned copy, photocopy, a photograph of somebody's passport, have a video call with them, and they would hold up their original document next to their face, so you could confirm it was them, and that was perfectly fine. But that was only from March 2020 until the end of September last year. From September, we're now kind of out of COVID, and we can conduct a check online, but you have to have the original document in your hand. So the individual would need to send you their passport or whatever their right to work evidence was, and only then could you conduct a right to work check via video call. Traditionally, the Home Office have always required you to have that check in person. So you are satisfied the person in front of you is the rightful holder of the document they're presenting. I think the Home Office have, particularly in the wake of COVID, accepted that working practices, work patterns are very different today than they were 3 years ago, with many more home and remote workers, and therefore have adjusted the policy to suit. So yes, you can, but you've got to have the original document.
Perfect. Thank you. Another question is, do you have to do a right to work check on a European employee?
Yes. So as of 2021, so the end of June 2021, EU nationals require approval just like anybody else. So those 27 nations are treated no differently to any other non-British or Irish national. We left the EU the end of December 2020, but the EU nationals then had a 6-month grace period in order to obtain either settled status or pre-settled status. So up until the end of June 2021, there was still no requirement to conduct a right to work check any differently to you did to a British national. But post 1st July 2021, we should be conducting checks just like any other overseas national.
Perfect. Thank you. And then we've got a question from Lisa. If you've got a share code outcome and I've downloaded the PDF, are you able to complete the right to work check and imposter check virtually using the downloaded document and a call with the candidate?
Yes, so as long as you've got that PDF and the individual on the other side of the video call looks like the person in the document, then that would suffice.
Perfect, thank you. Topeka would like to know, how often does the Home Office audit or check?
So, well, that is quite interesting. So originally, and up until pre-COVID, they were committed, and I use the word advisedly, they were committed to undertaking an audit during the life cycle of every sponsor's licence. They have, in the 15 years that the sponsor licence system has been in place, they have never achieved that. But they have said at a number of user group meetings in the last few months that compliance is going to be a main focus this year, because they have not been able to do as many compliance visits as they would have liked, particularly during COVID. So it is going to be a focus of their attention. There is absolutely no doubt. I think statistically, something like pre-license applications, they audit around 30%. But again, that's a target rather than that's an aspiration rather than an achieved target. They still, most unannounced visits are based on intelligence reports around, and as Darren mentioned earlier, kind of possibly changes that have taken place in companies' house have not been reported, allegations that have been made that are investigated, and then there seems to be something worth investigating. Most compliance visits are arranged, are pre-arranged.
Thank you, Julian. That leads quite nicely onto our next question, which is, how does it work when Sable does a mock audit?
So basically what we will do is, depending on the size of the organisation, it'll either be myself and a colleague will attend. We're normally on site for anything up to 4 or 5 hours, and we will interview the authorising officer, the key personnel. We will go through their systems and processes. We will normally audit, again, depending on the size of the workforce, anywhere up to kind of 8 or 10 HR files, either electronically or manually. We will, if there are sponsored workers, we will normally interview 1 or 2 sponsored workers to validate and verify that the cause they've got is what they're doing, what they're being paid. We'll ask to see their salary slips. We go through, and it is a mock audit. We don't come in with stab vests and say we're the immigration police, but we do a serious, lengthy audit, and at the end of it, we produce a report. I would say, in my experience of doing audits for 15 years, very rarely do you see a company that is 100% tickety-boo. Most clients have some issues that they are not fully compliant with.
And thank you, Julian. We've got a few questions on DBS checks. Firstly, how to do a DBS check for an international worker, and whose responsibility is it to provide the DBS, the employer or the employee?
Well, it'd be the employer, because I don't think
employee.
I don't think an employer. I don't think as an individual you can do a DBS check. I don't think so.
It needs to be done on you rather than
by you.
Yeah.
As far as I'm aware, most of the background screening companies are able to do that. So if you do it in-house, I think you can still do a DBS check on somebody who is not resident here.
Perfect, thank you. John would like to know if there's been any updates in terms of the process post 1st of January 25, when there will be no more physical BRP codes, BRP cards rather.
Well, I mean, it'd be no different to it is meant to be now, really. The individual will still be able to generate a share code, and it will just be an electronic status. So a lot of you who have employed overseas nationals will be familiar with the share code, logging into the Home Office site and downloading that PDF, and it'll be exactly the same as that, but they just won't have a physical card.
Perfect. And is there any indication on what will replace the physical card?
Well, not at this point, no. More often than not, the Home Office, and this is the case in this situation, the Home Office have an aspiration, and then just before it's due to be released, will delay it as they work out how they're actually going to deliver it.
Yeah, publicise and say this is what we're going to do, and then they have to work out how they're going to do it.
Yeah. And then they go back and go, right, guys, we've said we're going to do this. We've got to figure out how we're going to do it. So it's one of those things that at the moment we don't have any visibility as to what it will look like.
Perfect, thank you. Somebody else would like to know, if you're sponsoring someone that's already working for the business abroad in the foreign office and they're wanting to relocate to the UK office under sponsorship, how do you keep records, or what records are required to show the recruitment process?
It depends.
I mean,
it depends the basis under which you're assigning the COS, really.
Yeah, I mean, my advice normally to a client is to keep at least a skeleton record in the UK. So their original offer letter, their original employment contract. The UK office would probably have a copy of their assignment letter confirming details of that kind of international assignment. A lot of the background stuff, background screening, the references, kind of recruitment methods used, etc., will be in the overseas head office. It would be an ideal situation if they made a carbon copy of that record and kept it in the UK for inspection. But with intercompany transferees, the Home Office doesn't expect as much info because it's not been a local hire.
Perfect, thank you. Another question, is the IDSP check for a statutory excuse for someone? And if a British citizen doesn't have a passport, how would you do the right to work check?
Well, that's often a problem. I mean, there are alternatives to a British passport. So you could show a full British certificate, so that's a full one with mother and father details on, plus evidence of their national insurance number, and that would satisfy the List A requirement. So there are alternatives available if there's no passport. I mean, it doesn't happen very often.
No.
But it's there. It would be NI details plus some other evidence, and normally that would be a full birth certificate. I think often I've had employers who have come across this, and I've kind of assessed their files and seen a driving license, which is all very well for right to drive, but not very good for right to work. So it does need to be much more substantial than just. It's not about photo ID. I mean that covers the who they are bit, but the right to work part is quite different.
Perfect, thank you. Are there additional obligations as a sponsor if you want to get rid of a sponsored worker?
No, I mean, no. It requires notification to the Home Office, and that's why they will at that stage they will require those contact details, because they will then reach out to the migrant to clarify what their situation is. Now, generally there is a lag between that, so if they are changing jobs, it won't be an issue, but you will still need to provide those details to the Home Office when you notify them of the termination of employment for whatever reason that is.
I think the Home Office are quite concerned. Well, you could have somebody on a 5-year visa, and if they leave your employment, they have all this visa left. So the Home Office want to keep close tabs on those individuals, that they don't just disappear into the ether. From an employer's perspective, you are responsible for them. You sponsored them in, you brought them into the UK, and therefore you're answerable for their actions. Whilst they're in your employment, they're within your control. You know what they're doing. If they've left, then as an employer, you don't want to have that responsibility. You want to tell the Home Office as quickly as possible, look, they're no longer under our control, and then you can pass that back to the Home Office, and you'd have 10 working days to do that.
Absolutely. And then, as Darren quite rightly says, once you've notified them, it then becomes a Home Office issue. So you're abdicated of all responsibility.
Thank you. What happens if the Home Office inspects and isn't happy with the sponsor compliance responsibility?
Depending on the reason they're not happy, they will either downgrade the license from an A to a B, which basically means you can't sponsor any new migrant workers. and they will provide you with an action plan, which they charge, and you will then have to go through that action plan, implement the recommendations. They will then come out, reassess, and if they are happy, they will return you to an A grade, an A rating rather. If they revoke, then the sponsored migrants that you have employed will no longer be able to work, and you will not be able to apply for a new licence for at least 12 months. So depending on what the issue they find will depend on which one of those. They may not do anything. If it's a minor infringement, then they may not do anything. But if certainly if it's anything around right to work and there's some evidence of a poor or non-functioning process, they will definitely have some issues, because that may actually be potentially leading to a civil penalty and et cetera, et cetera.
Yeah, the problem is when they find problems with right to work, it then gets referred to the civil penalty department, because then it becomes an enforcement issue, which they will fine you for. So it becomes much more serious an infringement on the licence. The other thing to point out is if they do have a problem and they downgrade you to a B rating, that B rating is a temporary rating. So you can't stay in a B rating. You'll have to fix the problem or you'll lose your licence.
That's very true.
Perfect. Thank you very much. Brian would like to know, if you hired a sponsored worker through recommendation, what documents would you require to evidence the recruitment process?
You can't.
It would essentially be, I mean, from a record keeping perspective, it would be no different. You would still be expected to have details of their CV, their references, their qualifications, etc. If it's a personal recommendation and there wasn't a formal recruitment process, then it is what it is. I think you just need to document that's how the person was recruited. I don't know if you agree or disagree with that.
I think fundamentally, I think they'd have an issue if there wasn't a recruitment process in place, to be honest. I think that would be my immediate thought.
I mean, presumably there'd still be some kind of interview. There would still be a record of
I mean, this is the argument around genuine vacancy and has it been made available. So I think that would be a very case-by-case assessment, to be honest. And if it was deemed that it would need to be advertised, then there would need to be that advertising process, and obviously all the documents related retained.
Perfect. Thank you. Tara would like to know, if somebody is sponsored on a 3-year visa and the person leaves the business just as the visa is about to expire, do we still need to notify the Home Office?
Well, that's interesting. I mean, if it's less than 10 days, possibly not. I would still advocate that even if it's a day before the visa expires, best practice should be to notify the Home Office.
Perfect. Thank you. There's a few questions around remote working and where a business doesn't have a permanent place of business. Can they get a sponsor license with a home address?
It becomes more problematic.
It does. It becomes quite tricky. I mean, there is nothing to prevent a company getting a sponsor license for remote workers. That in itself is not an issue.
Absolutely. Hybrid working is perfectly acceptable. They need to be satisfied in a compliance situation. They need to be satisfied that there is some management around that, and you know, so for example, the 10 days unapproved absence is is there a process in place to make sure that is monitored?
But I think from the Home Office perspective, they want the comfort of being able to visit a premises and expect to see some documents, or the system where they can access documents. I would probably suggest anybody in those circumstances to at least have serviced office facilities.
Agreed.
So there is a business premises.
Yeah.
There is no requirement for them to have, for somebody to have an office full of people. I think those days are quite long gone. So whilst you could have agile working, you could have people working from home, the Home Office, there would be an expectation of a commercial address that the Home Office can visit.
Yeah, I mean, even if you're providing, workers who fundamentally are on client side, they would still expect there to be, a central office. So I think just a residential address working out of a back room, I think it would not be a straightforward application. Let's put it like that.
I think it would be a red flag. Let's put it that way.
Yeah, I think that's fair.
Perfect, thank you. Milani would like to know, if a sponsored worker applies for indefinite leave to remain after 5 years, are they no longer considered under your sponsorship?
That's absolutely right. Once they have indefinite leave to remain, they're no longer considered a sponsored worker. They are free from restrictions, and there's no requirement thereafter to report any activity to the Home Office, as they're no longer sponsored by the business. They are in their own status.
Perfect. Thank you very much. I think that's most of the questions. There were a few quite specific questions that I've responded to directly or will respond to directly. So thanks very much to Darren and Julian. That was really a lot of information, but you've managed to explain it in a very succinct, straightforward way. So thank you very much. Just so everybody is aware, there will be a recording of the webinar, which will be shared with all attendees after. And if there's anything specific you'd like to discuss with us, our contact details are included in that email. So you are more than welcome to reach out to us at any time. We'd be more than happy to discuss your specific circumstances. So thank you very much for your time today.
Thank you.
Thank you.
Bye-bye.
Bye.